taxable. This varies state by state. Transfers are subject to tax. The are the transfers of property by will, transfers of property by intestate succession. If there's no consideration transfer made within 1 year of the death, if the value is less than 3,000. Transfers of a life estate where the transferor retains an interest, and transfers where transferee promises to pay or care for the transferee for life. That's a life estate that the parent would say to a child, if you come and live with me, when I die, you can have the house as long as you take care of me. Transfers where the grantor retains power to alter, amend, or revoke an interest or of the beneficiary. So that would be the revocable trust that we talked about in our last session when we talked about the ways to hold title to the property. Joint tenancy is subject to tax on death of one joint tenant. So again, this is the discussion that we had last time with joint tenancies with right of survivorship, joint tenancies by the entirety, tenants by the entirety. All of these forms of ownership also, when somebody dies, affect how that property is transferred. And again, inheritance tax differs greatly from state to state. If your clients reside in or own property in one of the 18 states that currently levies an estate or inheritance tax, their assets may face taxation, even if they are not subject to federal estate law or federal estate tax. So there's two taxes that come into play in 18 states. One is the state inheritance tax and the other is federal. In the remaining states, the federal estate tax law would be the only inheritance tax that would come into play. So this is an issue in this sample I give you. It's Arizona and Minnesota, but we typically see it in Pennsylvania and New Jersey, where in Pennsylvania, there is inheritance tax. In New Jersey, there's not, but a lot of people have a vacation home in New Jersey. And then you have to look to both states to decide whether there will be inheritance tax based on where the property is located and where the decedent lives. So these are complicated questions that the title company will raise, but will rarely resolve. In states like Virginia, Maryland, New Jersey, New York, where Florida, where the attorney is much more involved in the closing, the attorney will typically reach out to the estate attorney, or the estate attorney will also be handling the real estate. They will be working with a tax attorney. They'll be working through most of these issues, but it's important for you, I think, to know that there are issues that are going to come up, and if they're not addressed as soon as you go to agreement of sale, they could delay closing in setting up escrows for the taxes that may be due. So states with inheritance tax or estate taxes are Connecticut, DC, Hawaii, Illinois, Iowa, Kentucky, Maine, Maryland, Massachusetts, Minnesota, Nebraska, New Jersey, New York, Oregon, Pennsylvania, Rhode Island, Vermont, and Washington. So I call those states you should not die in as you're looking at planning for whether or not you want a lot of your assets to go to the state, or you'd prefer that they go to your heirs. So it's not the only issue in deciding where you want to retire to, because in some states like Pennsylvania, they also tax your retirement income. So you need to be, obviously there are a lot more issues related to taxes besides just estate and inheritance taxes. Always consult a tax attorney, which I am not. But I will tell you that when we're looking at an estate and the property is typically the first to be sold, there will be an escrow for inheritance taxes. So the inheritance taxes, if they're not paid, become a lien on the property. The title company is ensuring that there are no liens on the property. So when we get to looking at the estate, we'll ask for copies of the will. We'll ask for letters of administration. We'll reach out to the estate to see what taxes, if any, have already been paid. And we'll will typically hold 1.5% of the anticipated tax based on the value of the property. So you'll see an line item in the ALTA that'll be for the estate taxes that are being held. And we don't release those taxes, that escrow, until we have proof that the inheritance taxes have been paid. And then we'll either release it to the estate or we'll release it to the taxing authority. So frequently we'll get a letter from the attorney for the estate saying, please release the money to the Register of Wills because the estate doesn't have enough money to pay the taxes, and the remainder of that escrow is going to go to pay the rest of the taxes, and we'll release it once we are convinced that the property, the amount of escrow we hold is sufficient to cover the rest of the taxes. So you'll see that frequently when you have an estate that's selling the property. If you have an attorney that is representing your seller, typically they'll follow up with us on that escrow. If you're in a state like Pennsylvania where there's not attorneys used as often as in other states, and you're representing the seller, it's not a bad idea to put that on your calendar for 6 months out to follow up with the title company and say, where are you on this release of escrow? It surprises me how often I have to chase down the seller to give them their money back. So I'm holding it in escrow and I have a list of 20 files that all have an escrow being held for taxes. And I have to spend an afternoon a month tracking down the attorney or tracking down the seller, tracking down the administrator for the estate to say, I'm holding this money and I need to get rid of it. I need you to prove that you've paid the taxes. It's amazing how often that gets forgotten and people move on and they leave monies and sometimes significant money sitting in my escrow account while I'm trying to find them to release it. So it's a good idea if you want to calendar it, look for it in the 6 months to a year and come up with found money for your client if they've forgotten about it. Or nudge the attorney to do it. So who signs and what are the tax rates? It depends on the relationship to the decedent. So it's 0% if the child is 21 years of age or younger, or it's a spouse. There is no tax on transfer to a spouse. It's 4.5% if it's a grandfather, a grandmother, a father, a mother, any lineal descendant, or the wife, widow, husband, or widower of the child. It's 12% if it goes to siblings, and it's 15% tax for all others. So in a typical estate situation, and it's a husband and a wife, the spouse would say it goes to my spouse. If you die intestate and you have no spouse and you have no children, then it goes typically up the line to any parents or grandparents and then down to any siblings or nieces or nephews. And that means that you're going to be in a higher tax bracket. So for a sibling to receive an inheritance, it's going to be taxed at 12%, where a spouse would have no tax. One thing to keep in mind, and this is more of a legal issue, but you may come across it when we talked about owning property and trusts. If you have a child who is subject to a special needs trust and the parent wants the money from the sale of the proceeds after they've died to go into that trust is going to be taxed at 15% because it's not a real person. It's not the child, it's the trust. So the trust will be taxed at a higher rate than if the child were receiving the money directly. So how to clear the inheritance taxes in Pennsylvania, it's what's called a notice of appraisement. So the Department of Real Estate appraises a property subject to the tax within 6 months of the date of the filing. They send out a notice of appraisement that says that the taxes have been paid and they've been cleared. And there's typically a schedule attached to the tax return and to the notice of appraisement. we're looking at that to make sure that the property is included in that. So if there's 5 properties that were part of the estate and only 3 of them have sold, if the 2 that we're holding escrow on haven't been included in that schedule, we'll go back and say, you need to include this in the schedule because we need to make sure that there's ample money to pay those taxes. Let's see. So how to clear the inheritance tax, you can pay it at closing. So you'll see that on, this is a Schedule A that I said you need to see the premises A. It's got to have the value of the property and the taxes that were paid on it. So this is the Pennsylvania form. It's very similar in other states. Every state is different as to what they call it, but in Pennsylvania, it's called a notice of appraisement. So I said that there were federal taxes and there are state taxes. These are the tax rates, the filing thresholds for the year of death. So assuming that today is 2025, somebody dies in this year, the federal estate tax threshold for the value of the state is 13 million, almost $14 million. So only really high-end clients are subject to federal estate taxes. But yeah, you need to know what that threshold is, particularly if there's multiple properties in multiple states. And typically we see when the federal estate taxes, when that threshold is met, it's usually because they own several valuable properties. You rarely get to have a portfolio or an estate that's that valuable without a significant real estate portfolio. That's a great way to make money and save money. So our high-end clients would be subject to that federal estate tax. Okay. So that's what you need to know about death and taxes. Again, the most important thing, and I know a lot of people jumped on a little bit late, the most important thing is to know who your seller is and make sure that they are both alive. They don't have to be well. If you have a power of attorney, one of them doesn't have to be well, but they do have to be alive. They cannot sign an agreement of sale. They cannot sign a deed. And a power of attorney is not valid once the person giving the power of attorney has passed. So it's important to let your title company know, let your real estate attorney know as soon as somebody passes. From a seller standpoint, obviously, you can't sell after you've died, but from a buyer standpoint, it's important to read your agreement of sale because there are a lot of, it's not a lot, but in the agreement of sale, if you both sign the agreement of sale and one spouse dies, the seller can hold you to that agreement of sale, the surviving spouse. And I've worked for a number of new builders, new home construction builders, particularly who do the active adult 55 plus housing. And they'll sign an agreement of sale 9 months, 10 months in advance with the couple. And sadly, one of the spouses will pass away in the time that it takes to build the house. And I'll tell you, the policy of almost every home builder in that situation is they're going to require the surviving spouse to go forward with the agreement of sale and purchase the property. So if you're advising a client and they're buying in an active adult community, and there's a risk, obviously, the older you are, the higher the risk is that one of you may pass before you consummate the sale. It's important to know that the builder has the right and may actually hold your client to going forward with the property, even if they have no intention of ever moving into the property. The builder will require that they buy it and then flip it. So it's important to advise your clients on that as they get older as well. From a title standpoint, when we get the agreement of sale and we start doing our due diligence, we'll do typically a Google search on the client, on whoever has signed the agreement of sale. If there's an obituary that comes up, obviously that's a red flag that the person is no longer with us. We'll also look at the obituary to see how many heirs they have. If it says Mr. Smith was survived by 15 children and we are dealing with 11, we worry about where those other four children are. So we'll do our due diligence to find out, have they been estranged from the family, but they're still entitled to a share of it. So when we're asking those kinds of questions and we're looking for it, we're doing it so that we can make sure that if there are people who may have a right to the property and they're not aware that the property is being sold, we want to make sure that we raise those red flags. And that's why we're looking at that closely to see if there's anybody out there. That's also one of the things that when we talked about the enhanced policy versus the regular homeowners policy, the enhanced policy covers that. That doesn't mean we don't do our due diligence to try to locate all of the heirs, but if there's been a missing heir in the chain of title, the enhanced policy will pay the legal fees to cure that title problem and establish clear title for the client when they go to sell. So it's always a little bit of sleuthing that we do, a little solve the mystery to try to figure out who has the rights to the property and to make sure that the right people are selling it. And so any information that you have with regard to who the seller is that you can give us to speed that along is always super helpful and greatly appreciated, especially as we're looking now at more 30-day closings. So any questions on that fascinating topic? Things you didn't think you needed to know, but maybe you're glad you did?
Liz, I have one.
Sure, Rory.
Can you walk us through any scenarios where you were where you've seen people implement a tax strategy that's it was impressive or something that you wouldn't necessarily normally think about? Like I'm trying to, as I'm going through this and looking at all the taxable areas of, for estate taxes, are there any things, I'm sure there's a number of workarounds, and I know that you're not a tax accountant or a tax attorney, but what is the most creative way to avoid having to subject your heirs to this level of tax?
Putting putting the property in trust and having the trust and the beneficiaries of the trustee be the siblings are the people that you want to ultimately inherit is a really effective tool. It is a tool that you should absolutely, you shouldn't Google or use ChatGPT to create the trust. You should definitely reach out to an estate attorney or a trust attorney to create it. But that is a very effective tax tool that, when implemented properly, is super, super effective.
So can I follow that up so I understand this clearly? So you would create a trust, and then you would create people that are members of the trust, and then when the person that controls the trust passes away, the people that are a part of it would just basically step into that role, and there's not a taxable event.
They're beneficiaries of the trust, yes, and it's not a taxable event. It'd be like if you had it also in an LLC
Right,
and one of the members passed away and the LLC was created and set up so that the other um, members would take an increased percentage in that.
right. Okay.
Um, in most jurisdictions, that would not be taxed in Pennsylvania with transfer tax. There's an 80/20 rule with it, as long as more than 80% wasn't being transferred, it wouldn't be subject to transfer tax. With trusts, particularly, it's important if you're putting the money in the trust, there's clawback periods in most jurisdictions. So if you die, you put it in the trust, 3 weeks before you die, it may be clawed back into the estate because it wasn't set up properly or there wasn't enough time that passed. So, and again, every jurisdiction's a little bit different on that, but that's important to know. Another just a quick tip that I've used is in a state issue where the estate owns multiple properties. I had one recently where the estate had four properties, and the first two were sold, and the almost immediately upon the death of the decedent, and the title companies for each of those two sales held escrow because taxes hadn't been filed. And I would have done the same thing had I been selling one of those first two houses. But when I got to the third house, and that was now our title company was doing that closing, I didn't ask for there to be escrow held. I relied on the fact that escrow was held on the prior two closings. I looked at the amount. I was comfortable that there was sufficient amount already being held, and I didn't hold taxes. So, or escrow for taxes. So when you're dealing with multiple properties and the buyer picks the title company. So you're the seller, the buyer picks the title company. You could have four different title companies doing the four different sales. If you're getting to the third or fourth one, you might consider saying, hey, how about here's the altos from the other two closings. How about you not take an escrow on this inheritance tax? So that's a good tip if you're representing the seller to say to the third or fourth title company, I don't really think you need to hold escrow because the other title companies have held them. And here's the proof that they've been held. So that's a way to at least avoid having the escrow on the taxes.
Elizabeth, I have a silly question, or probably silly, but if you own properties in different states, is it best to have different trusts set up, or can you put properties from different states in the same trust?
You can put properties from different states in the same trust.
Okay, and that
The
doesn't
trust can hold anything. So it can hold real estate, it can hold accounts, it can hold stock, it can hold anything.
Okay, thank you.
Liz, one other question for when you guys are holding escrow for the taxes, how come? So you were saying the tax rates are as high as, like, say for a sibling, it would be 12%. Why do you only hold 1.5%? How does that protect you?
We hold 1.5% of what we think the taxes would be. So if it's a sibling, we calculate the tax at the tax rate at 12%, and then we hold that plus an extra 0.5%.
Oh, plus an extra 1.5%.
Yes.
I got you. Okay.
So it's 1.5% of what we think the taxes are going to be. So
So
we'll
are
be
you saying like 150%, or are you saying like, so say let's just use, say you thought it was going to be a $10,000 tax situation. You're saying you hold 1.5% or $15,000, or are you
yes,
holding, you're holding
1.5.
15?
We take more than we need.
So 150%.
Yes.
I see. Okay, thank you. So it's 1.5 times basically
Yes.
what you think the taxes would be.
Yes. One and
Got
a
it.
half times what we think the
Okay.
taxes would be. And it's interesting, so I just had a closing for a piece of property that was not it wasn't worth very much. The estate's probably worth $40 million. The first piece of property they sold off was worth $400,000. So the taxes is only going to be the amount of escrow is only going to be based on that $400,000 house, not on the $40 million estate, because they can't um, they can't lien what they don't own. So once it's sold, that's the only amount that's going to be subject to the tax for that particular property that you're insuring title for. So you don't need to take the full amount, but you do need to take the full amount of what would be transferred for that property. So there's no magic formula. There's a standard in the industry, but when you get into multiple properties, it's always the most title companies will go back to their underwriter and say, "What do you think?" Because at the end of the day, in title, it's the underwriter that's insuring the title. It's not United Land Transfer Services. We're the agent for the underwriter. So all of the bigger issues with regard to what is the right way to go or what's the best way to protect ourselves are frequently kicked up the chain to the underwriter so that the underwriter is comfortable with the risk that the title agent is recommending, but the underwriter at the end of the day is the one that makes the decision. And I think a lot of people don't really understand that relationship either, that we are a title agent, much like your insurance agent would be. It's not your, O'Connell Insurance Agency that's insuring your home. it's State Farm or it's Allstate. They're just the agent for them. So we're the agent for Fidelity, for First American, for Stewart. They're our underwriter and they make those bigger dollar decisions for us. Which is why it's important when you're dealing with a title company and you're representing a buyer that you're going to a title company that is underwritten by a significant major player in the market, like a Fidelity or First American or Stewart or an Old Republic. Some of the smaller underwriters may be more flexible in their, or maybe more risk tolerant, but when there is a risk and there is a claim, they don't have the backing to pay that claim. So you want to make sure that when you're shopping for your buyer, that you're looking at a title company that also has a strong underwriter. So totally off topic, but interesting to know because that's also a misconception that I think a lot of people have, that they think that their title agent is actually insuring the property, and we are not. We are just an agent for the underwriter. Any other questions? I feel like sometimes when I make these presentations, and I think it's because I am an attorney, um, I am also advocating for the employment of all attorneys. It really is. I mean, if your client is considering setting up a trust, they definitely need to do it with a licensed, knowledgeable real estate trust tax attorney. Um, to make sure that they're doing it in the most compliant and safest way, and also to make sure that the wishes of their client are being implemented with a tool that's going to allow them to disperse their wealth in the manner that they want to. And super important to start with the simplest of all documents, which is a will. It really, if you have a will and everything goes to certain people, that makes it so much easier. So when you're talking to clients, and I think we were on the call with the woman that was talking about um, doing seminars. If you want to do a seminar with your clients and add value to where they are from more than just a real estate, bringing in an estate attorney and a tax attorney to talk to them would be, I think, an invaluable way to engage clients, to bring them in, to offer that as a service, and just a lunch and learn or a dinner with a knowledgeable estate attorney.
Liz, as far as estates and taxation for trust, are revocable and irrevocable seen as the same as you state for taxation?
So no, I believe they are viewed differently from a tax standpoint as well, because an irrevocable trust is you can't change it, you cannot make any changes to it, whereas a revocable trust you can, and because you've got flexibility within a revocable trust, I believe it's looked at differently. But I again, I'm not, and from a tax standpoint, I'm not a tax attorney, so I know the difference between the revocable and irrevocable, and I believe that they are treated differently from a tax standpoint, but I'm not 100% sure on that.
Okay, thank you.
Anything else? Any suggestions for another topic that you would like to know more about? If anybody wants to throw out some topic suggestions, I'd love to talk about what you're interested in. Sherry, you're learning so much. What do you think you need to know?
Uh, Quite a bit. Um, I mean, I think this affects all of us, both for our clients and personally. And it just makes me realize I need to make sure we're squared away on a personal level for our heirs and children. But
Oh, absolutely.
so any more of this is excellent. I found this really helpful. But also, I really found helpful that with clients to follow up in 6 months is and make sure they've taken the money off the table that's still there. I think that's a really good reminder for us as agents where we could add value.
Absolutely. It's so frustrating for me to track down people. And the
Yeah.
longer it goes, the more likelihood is that they have also passed on. And then and I'm back to doing the same thing. I feel like I read more obituaries than your average bear should ever have to read. But I'm always trying to find people, and that's an easy way. It's one of the only ways I know to find people because I've got money I want to get rid of. So, the first thing would be to try to not have escrow being held, which if it's multiple properties, you can talk to the title agent about not holding the escrow because the other agents are. But the other is if it's being held, make sure that they're aware of it and then they follow up with it. Um, it's a stressful time. If you're dealing with a fresh estate, it's a very stressful time for your clients and it's very emotional. And it's amazing how quickly they just want to close that chapter and move on, and they leave money on the table all the time. I had a guy call me. He had a check from an estate for $17,000 from, I think it was from 2001, and he written on one of my agencies, and he wanted me to honor that check. And I was like, how how is it that you still have a check from 2001? And he said, I was so stressed out over the sale, and there was litigation involved with the family, and I just didn't want to deal with it. And then 3 years ago, my attorney gave me back my file, and I couldn't look at the file, but I just started looking through it, and now I found this check. I can't honor that check. I have no way of knowing whether or not that check cleared the bank 20 years ago. But he sat on it, and I can't help him. I mean, I can't honor a check from that long ago, and I have no idea why he sat on it. But it's amazing how frequently people walk away from significant sums of money because during an estate and the closing of the will and the death of a parent or a loved one, the last thing they're worried about is, the $15,000 I'm holding in escrow. So it is a good idea to follow up with them.
Liz, what is your responsibility for that situation when you're the escrow agent? I understand you're trying to chase people down because you don't want to hold it, but is there a statute of limitations of how long you're allowed to hold that?
There isn't, but what typically a title company would do, and in this case, it was that title company that was holding the money had ceased to exist, and we just bought the name, so it wasn't us, and I didn't have access to their records. But at a certain point, when you're winding down your business, or I try to look at it every 5 years, the title company is obligated to escheat that money to the state. So after 5 years, I look at it, I see if I can find the people. I'm obligated to make 3 efforts to contact them and document those efforts, and then I send it to the state. And then if you are looking at unclaimed property, most of that is property that's been escheated to the state. So I would clear out my account, give it to the state, and hope that the state can find it by the way that they do those notices. So also just interesting on the escheating to the state, if you have a gift certificate and it's 2 or 3 years old and the restaurant or the store says that they're not going to honor it anymore, you can ask them for proof that they've escheated that money to the state. If they don't have proof that they've escheated it, then they still have it and they're obligated to honor it. So there's another quick tip. Okay, well, if anybody has any other suggestions for topics, shoot me an email or let Kristen and Dave know. I'd love to talk about what you want to talk about. I think my next topic may be fraud, or I may get into we get a lot of questions about divorces and how that gets handled, and I might try to do a little bit on family law and divorce law and child support and those kinds of issues which come up at more closings than we'd like. So if that sounds like a good topic, I'll work on that as well.
Liz, I know we've talked about ways to take title. What would be helpful to me if you could mix it in, more or less wouldn't be a whole session, but different ways to take title for investments, investment properties, secondary homes. Because I know once you LLC, you have to take commercial insurance. So I know there's a few ins and outs once you get above, 3 doors on certain things. You have to take commercial. There's a lot of ins and outs when it comes to the investment area. If you could at some point mix that into a session, that would be helpful as well.
Brendan, I think that's a whole session. That's a great idea. Commercial real estate is different than residential real estate, and from a title insurance standpoint, it's very different. From an investment standpoint, it's very different. So absolutely. We do a lot of commercial deals as well, and they do have a lot of different nuances in it. For a first-time investor to a seasoned investor, there's a lot of nuances that I think is a whole nother class. That's a great idea. Great. All right. Happy Monday, all. Make it a great week.